I am Anupam Chakraborty, Professor of Law, NAIR. Today, I have been entrusted with the topic RTI, Right to Information, 2005. Gentlemen, as you know, the Right to Information Act is the most important act, and it is activated for the democratic governance in the country. And this is a fundamental right where the people will be able to get all types of information. Now, I am coming to the chapter introductions. First of all, RTI has a dynamic role in constitutional governance. It is in consonance with Article 19, Clause 1, Article 14, and Article 21 of the Constitution. It is a right for the illuminations of our democratic rights. Now you see the rights which is enshrined in the Constitution, it is illuminating the democratic rights. Without RTI, democratic rights are not illuminated. So it is a very effective right. It is an effective mechanism for access to information. We can get all types of information what is in public domain by dint of the right to information. It has repealed the Freedom of Information Act 2002. Now, gentlemen, I would like to mention that prior to this right, there was Freedom of Information Act. Due to some fundamental defects and lacunas, this Freedom of Information Act has been repealed by the Right to Information Act 2005. So previously there was 2002 Right to Information Act, and this act has been repealed by RTI. RTI came into force on October 2005. This is, as you know, regarding that. RTI, we find hierarchy of information. We find hierarchical structures of information in RTI. What is the hierarchical structure? First of all, the information will come to PIO, and then it will go to CPIO. Then, being aggrieved with the impugned order, the applicant can go to CIC, Central Information Commission. So there are three-tier structure in the RTI. That is why it is told that RTI we find the hierarchy of information officer. Then RTI has 31 sections. RTI, the act is very small. The statutory provisions of RTI is only 31. But under this 31, all the information has been accumulated. What is the organization? What is the structure? What is the functions? What is how the information will be asked? How the information will be disposed of? What is the exemptions? All these activities are done in 31 sections. It has 2 schedules. RTI has got 2 schedules and 6 chapters. Then the heart and soul of RTI is chapter 2. I would like to get you remembered that the chapter 2 of the RTI has got 3 to 11. That is 9 sections, and these 9 sections are to be taken into consideration. These 9 sections are the cardinal principles of RTI. I will come one after another. But there is some reasonable restrictions as enshrined in the constitutions in Article 19, Clause 2. Gentlemen, as you know, in our constitutions, certain freedoms were given. Right to information, right to movement, right to freedom of speech, right to live, right against exploitations. These are the freedom has been given. But along with the freedom, we have got some restrictions. So these restrictions are also there in the RTI. These restrictions, when I will further give you speech, I will give you the information that the restrictions are enshrined under Section 8, Clause 1, there are 10 restrictions. In Section 9, in Section 11, in Section 10, there are some restrictions, just like the right to freedom, just like the constitutional freedom. Constitutional freedoms are not unfettered. Similarly, in the Right to Information Act, these rights are not unfettered. There are some exemptions, there are some restrictions. Record as defined in Section 2I of RTI, which includes any document. Now, what does it mean, document? Documents means manuscript and filed by macrofilm, microfiche, facsimile copy of the documents. And Section 2J of RTI defines right to information, which means information accessible under this act, which is under the controls of the public authority and includes right to inspections of work, documents, records, taking notes, extracts, certified copies of documents and records, and taking these other things are also taking certified samples of materials, obtain informations of any form. Section 4, Clause 1, Subclause A, casts a statutory duty on every public authority. What is the statutory duty? This is very important. I will come later on. The statutory duty and responsibility of the RTI activist is that he will disseminate the information. He will spread out the information. When the information comes to him, he will spread out the information. What are the modus operandi of spreading the information? He will spread the information by way of a network. Network means through media, through publication, through newspaper, through any other means, through notification, through citizens' charter. So he will disseminate all the informations in a proper manner, maintain all records and computerize it. It is also very important. He will maintain all records and computerize it. Computerizations and maintenance of record is the cardinal principles of RTI, and he will do it. Section 21, remember, Section 21 gives immunity to RTI officials against any legal proceedings in the court. If anything, any questions is raised in the court or any case is raised in the court, so RTI officials are legally exempted. That means there is legal immunity under Section 21. RTI officials cannot be tagged under legal proceedings. Section 22 gives overriding power to the provisions of RTI. This is also a very important thing. Suppose any act which is clashing with RTI, Right to Information Act, RTI Act will prevail. Suppose the Official Secrets Act is one of the acts where RTI is clashing. Previously, we have implemented Official Secrets Acts under 1923, and these acts are some of the acts where we are not bound to disclose all these things. But if clashes with the RTI, that means if their public interest is becoming predominant, then RTI Act will prevail. So that is the sanctity of the Act. Section 21 empowers the Act that no suit in the court can be filed or will be entertained. Section 23 again empowers the RTI Act that against the decisions of the RTI Act, no suit can be filed in the court. So this is a very important thing of the RTI Act. It is important to know the provisions of chapter. It is important to know the provisions of chapter 2, that is the preliminary chapter, that is section 2F of RTI, which define information in material form. You should have to know this section 2F. What is information? This is a very important thing under RTI. What information? Information in any material form. Information in many material form means in the material form, information which is available, including records. Information also includes records, documents, memos, emails. Remember, email is also an information. Opinions, advices, press releases, circulars, orders, logbook. Remember that logbooks is also a piece of information, and contracts, reports, papers, samples, models, data materials held in any electronic form. If it is electronically preserved, and information relating to the public body which can be accessed by the public authority under any other law for the time being in force. So these are the plethora of information, different types of information, records, documents, memos, emails, opinions, advices, press releases, circulars. So you should have to remember all these things, that these are the plethora of information. These are the types of information through where the RTI official will have to handle this information. Next. Section 3 confers all citizens right to information in the form of records as defined in Section 2I of RTI, which includes any documents, manuscript, file, any macrofilm, macrofiche, facsimile copy of the documents. Now, I have already told you Section 2F has got different information. Section 2I also given what is documents, what are the documents, manuscripts. These are also information and it can be given. Section 2J of RTI defines right to information, which means the information accessible under this act, which is under the controls of the public authority and includes the right to inspection of work, document, records, taking notes, extracts, certified copies of the documents and records, taking certified samples, materials and obtains in information in any form. Section 4, Clause 1, Subclause A casts a statutory duty on public authority to maintain all records and computerized state. So computerization is a very important thing to reckon with. Then I will objectives of the session. What are the objectives of the session? Objectives means that what are the aims and objectives of the session, differentiate responsibility and the liability. Now any of you can tell these things. I will ask questions later on also, that what is the responsibility and what is the liability. Responsibility means some moral obligation and liability means legal obligation. So there is difference between responsibility and liability. Responsibility is a sort of moral obligation and liability is a sort of legal obligation. You are legally bound, you are morally bound to give the information in the, if you are an RTI activist. Explain the importance of RTI Act. You have to, what are the important things? I will come later on. Identify the exemptions under RTI. In Section 8, Clause 1, there is 10 exemptions. I will come one after another. List the time limits of the response. What is the time limits? What is the time span given to the different hierarchical authority in the RTI? Suppose the PIO, when the information comes to PIO, he will have to dispose of the information, dispose of the reply within a span of 30 days. Suppose it comes to CPIO for the disposal, it will have certain stipulated period within which he will have to dispose of the information. So list of how you will dispose of the information. Second, list of time limits. Clear the doubts through case studies. I will, in the concluding stage, I will give you some case studies, and on the basis of these case studies, I will clear your doubts in regards to the many problems and describe the do's and don'ts. What are the do's and don'ts of RTI? It will be taught to you later on. Then, what is the objectives of RTI? Here, it is aims or objectives of the RTI is a very important thing. The objectives of the RTI is to promote transparency and accountability. These are the two pillars. That is, transparency is one pillar and accountability is the another pillar. On the basis of this, RTI is standing. And after that, what is the purpose of, why the purpose of has been introduced? To promote transparency and accountability. By dint of transparency and accountability, we will be able to contain corruption. The main idea, the cardinal principle behind the RTI Act is to contain corruption. If you do not contain corruptions, the people's participation in democratic process will not be enhanced. And if the people's participation in democratic process is not enhanced, we will not be able to, citizens will not be empowered. So the main objectives of the RTI is to promote transparency and accessibility. Then for these two reasons, if it is done, then corruptions will be combated. And if the corruption is combated, people's participation will be enhanced. And if the people's participation is enhanced, then people will be empowered. So it is a closed door circle. It is like a circle. As I have already mentioned, that the RTI Act 2005 is a landmark legislation, provides Indian citizens a right to access information, and ordinarily under the controls of the government authorities, where it is the government under the federal level, the government under the state level, the government under the local level. So in three levels, the information are stored, and these information are given to the PIO, and when the public comes to the PIO, and PIO will disseminate the information. The Act consisting of 31 sections, as I have already described to you, so it is not needed. Next. Some questions to ponder over. Gentlemen, remember these important points. Remember these important points. Sometimes you may be asked with the questions that is there a need to watch the watchman? RTI is himself a watchman. RTI, if it is implemented, then it is a watchman. By writing down in rules and regulation, by writing down in papers, it will not suffice your problem. The RTI is a watchman, and there must be a democratic process. That is a watchman. A watchman will watch as to what the government is doing, what are the budget allocation, what are the sports allocation, what are the taxation policy of the government, how the government is running, what are the development scheme of the government, what are the environmental scheme of the government, what are the political scheme of the government, what are the educational policies of the government. So it is the watchman who will watch and will disseminate the information. If so, RTI can be used as a watchdog. Definitely, RTI is a watchdog. RTI watches and asks government the questions as to how you are doing, what are the policies. So RTI is also a watchdog. Is RTI Act an invasion to official secrecy? Gentlemen, as you know, that if you are officially hiding the information, if you are officially making secret the information, people will not be able to know all these things. So people should be given a liberty. What liberty? By dint of empowering the RTI, by dint of the sections of the RTI Act. They have given the power. So the official secrecy is broken. Suppose, as I have already told you just before, that there is Official Secrets Act. You know, during the time of the British era, in the colonial period, there was Official Secrets Act. There was many important black acts, suppose Carlisle Circular Act, Lyon Circular Act. There are many black acts introduced by the British to combat the freedom fighters, to combat the democratic urge of the people. So one of them is the Official Secrets Act. Anything which is officially secret cannot be published before the public. So this official secrecy has been broken by RTI Act. Not in every respect, but in a large extent, the official secrecy has been broken. And we get to know what is the government is doing, what are the activities, what are the rules and regulations, how the government is doing, what is the budget allocations. what is the environmental programs of the government, how the government is functioning. So if there is official secrecy, we will not be able to know. Is provisions of RTI an extension to the provision of whistleblower? Now, first of all, before examining these things, how many of you are knowing about whistleblower? This is a very important thing. Who is a whistleblower? Whistleblower is a citizen, is a conscious citizens of the country who acts actively to know the power and policies, know the rules and regulations of the government. And if these rules and regulations, if it is properly implemented practically, then these things the government will run. So the rules and regulations which are maintained by the government, which are introduced by the government, if the government is introducing these rules and regulations in practical field, it is the duty of the whistleblower. He will point out the differences. He will point out the loopholes where the government is lacking, that these things are lacking in the government and this should be rectified. So whistleblower will just emphasize upon the loopholes of the government. He will just bring to the public, he will make the people conscious about the rules and regulations where the government is lacking. So this is a very important thing. Through RTI, we will be able to activate and empower the whistleblower for democratic governance of the country. Are records required to be preserved for longer periods? Now, according to record retention period of the railway, as far as the railway is concerned, we are concerned with the railways now. Therefore, we are preserving the records according to the record retention procedure of the railway board, and on the basis of that, we are retaining the records. We will come later on how many days RTI records are to be preserved, how many days railway board's records, important records are to be preserved. Does RTI gives any new power? Definitely, it has armed us with a new power. It is a cap of glory in our democratic government. So RTI has given many new power under sections, 31 sections. As railway became overburdened with RTI, generally the peoples are telling that there are so many questions given put before the PIO or the API, CPIO, so it is overburdened. It is not so, because many citizens of India have got every right to know about the government activity. So it is not overburdened. RTI has not overburdened us. Is implementations of RTI an unnecessary drainage of public money? Not at all. By a simple amount of a public money, depositing public money only 10, we are getting the plethora of information, different pieces of information at your doorstep, at your threshold. Therefore, RTI is not unnecessary drainage of public money. Is responsibility of the PIO under RTI Act actually a liability? Definitely, it is a moral and legal responsibility for the PIO, on the part of the PIO, to disseminate the information. Now we are coming the main part of the RTI, that is the aim of the Act. So by synthesization, we will come to this conclusion that RTI Act is meant for transparency, accountability, and accessibility. Why these things are needed? Because if these things are, in the absence of these things, we will not be able to curb corruption. So main aim and intentions and the objective, whatever may be, of RTI is to curb the corruption. And corruptions, if we are curbing the corruption more and more, good governance, the flower, the petals of good governance will come out. The flowers will unfold its petals by dint of good governance, by dint of doing all these things. So these are the cardinal principles you should have to remember. Transparency. Without transparency of the Act, nothing will come out. Accessibility. If the peoples are not accessible to the information, nothing will happen. And accountability. Who is responsible for the lab loopholes? Who is responsible for the lapses? That will have to be taken. And these are all these things for curbing corruption. To prevent corruption, the RTI Act has been built, and these are the aims of the RTI Act. What is information? Gentlemen, nothing to be repeated here. We have already delineated in our previous speeches that section 2F, that records, documents, memos, emails, opinion, advices, press releases, circulars, these contains in the RTI Act, so nothing to be repeated again. What is the right of information? This is also the same, section 2J, the inspections of work, documents, records, taking notes, extracts, certified copies of the documents, taking certified samples of the materials, maintaining information in the form electronic mode. So these are the important things of RTI. Here comes the main important point of section-wise main important point, section 5. Section 5 of RTI Act has given delineated the public authority. In the public authority, who is the public authority? At the divisional level, PIO. PIO is the public authority, Public Information Officer. Who is the PIO? PIO may be a senior DCM, maybe senior DPO, a senior branch officer of the division at the divisional level will be a PIO. And if anything is not under the domain of PIO, if it is under the custody of APIO under section 5 clause 4, the post of APIO has been created. APIO will assist in regards to the information in PIO and deemed PIO. In absence of the PIO, there will be a post deemed PIO. He will be working. Similar is the case in regards to the railway board. Next. Then section 6. Section 6 is a very important thing. What is in section 6? Generally, what happens? Initially, a fees of ₹10 will have to be given for getting an information. And if you are a BPL card holder, below poverty line card holder, then no fees will have to be deposited. You will get the information free of cost. That means an applicant will, by dint of depositing an amount of ₹10 only, he will get plethora of information. And then if you are a BPL card holder, then you are at liberty to get the information. What is the modes of getting the information? Information which is in electronic form, only by depositing an amount of ₹50, you will get the floppy. So information will be given to you. And these are all written here, certified copies of samples, materials, actual cost. If you want to get the certified copies by inspections of records or any other thing, you will get only actual cost of that particular copy. And inspection of documents, here also RTI has rules, regulations has delineated that for the first hour, no fees. And for the subsequent hours, an amount of ₹5 will have to be given. And certified copies, what is the cost of each certified copies? Only ₹2. So you can get that, as I have already told, that RTI is not a drain of money. By dint of ₹10, a person can get all types of information, what is in public domain available. He will be sufficed with the information. If he is a BPL card holder, no money is required, and the denominations of the money as charged by the government is reflected here. I will share my PPT later on to you. Disposals of request. Now, this is a very important thing under section 7. Disposals of request has been delineated. How the disposals of request has been made? It is very easy. You see on the left part, you are kindly see the left part of you will see the citizens. The citizen, as per section 3 of RTI, only citizens are entitled to get the information by dint of depositing an amount of money. If he is a BPL card holder, he will not have to fill up this money. He will have to, and if he is a non-BPL person, he will have to give an amount of rupees 10. Now, when in this information, he is citizens is an applicant. If he gives the information by way of request to the PIO, and the PIO, if the PIO has got the information in his public domain, he will definitely give the information. Or if the information is not readily available, it is under APIO, he will give it to the APIO, and APIO will suffice the information, and he will give the information. So, by adding a fee, a nominal fee, as the case may be, you are getting the information. And similar is the case of third party. A third party information can also be given as per the case. And when it comes to the PIO, when the request letter in regards to an RTI information comes to the PIO, what the PIO will do? He can transfer the application to the APIO, or he can accept the application, or he can reject the application. So the reason time of in this connection, he can accept it, the PIO can accept the application, and PIO can reject the application. What is the procedure of rejection? I will come later on. Next, third party information. It is very important. Third party has been mentioned in section 11. Who is a third party? Third party means a person other than a citizen making a request for information and includes a public authority under section 2L. A third party may be a public authority also. A third party may be a public authority also. He can ask for the information. So, and the third party information can be categorized into two parts. One is information in fiduciary relationship, and another is personal relationship. Information in fiduciary relationship, what does it mean? I will tell later on. Fiduciary relationship means the relationship of trust. Suppose the doctor-patient's relationship. This is, no, previous one you just. Previous. This was the information, fiduciary relationship, doctor-patient's relationships, purchaser-purchased relationships, seller-purchaser relationships. There are fiduciary relationships which are very close, and these relationships are completely based on trust. And personal relationship, that is husband-wife's relationships. Husband-wife, that is a very close relationship where the information is personally very close. So I will come later on. Next, then time frame for disposals of request. This is a very important thing for all RTI activists and those who are participating and joining. Remember it, how this information comes and how the information goes and what is the time span. The time frame for the disposal of information. As I have already told, if an information comes from the applicant, it will go to the PIO. What the PIO will do? He can either accept it or reject it. If he is rejecting it, the cause to be given. If he is accepting it, the information will be given to him. So this time span, the time frame or the time span here, this is a very important thing. Suppose PIO, if the information comes from the requester, he is a requesting man, is a citizen or an applicant, whatever may be, it comes from the citizens to the PIO. If it goes to the PIO, within 30 days, he will have to dispose the application. If it comes to APIO, it will take 35 days. That means it will go to APIO. PIO will give within 5 days of the receipt of the application to the APIO, and APIO will give the information. Third party, if it relates to the third party, the time span is 40 days. If it relates to the life and liberty, life and liberty is a very important emergency question. If it If it relates to the life and liberty of the person, it will be, the time span is 48 hours. And security and intelligence agencies, it is 45 days. Now, the question, pertinent questions here, in regards to PIO, APIO and the third party, you are all well acquainted that within a span of 30 days, information will have to be disposed of. Within a span of 35 days, information relating to the APIO will have to be disposed of. And the third party, it will have to be disposed of within 40 days. Now, take the fourth one, life and liberty. Can anyone tell anything in regards to this life and liberty? Why it is within 48 hours? Now, life and liberty is a vital question. It is an emergency question. It's a very urgent question. So, the reply will have to be given within a span of 2 days, that is 48 hours. So, 48 hours is stipulated there. Life and liberty. Suppose an accident has taken place, and a train accident, we peoples are restricting our arena in the railways. All the railway peoples are there, and there are other peoples also. I invite their attention here. The most important questions here is the life and liberty. The life and liberty, if the life and liberty of the people is concerned, then the information will have to be given 48 hours. Suppose an emergency train accident is taken place. A massive flood has taken place, inundating the entire area in the railway line. Suppose the cyclone has taken place, earthquake has taken place, a natural calamity has taken place, and any other things in regards to the urgency has taken place, then within a span of 48 hours, we have to disseminate the information. There is time span is only 48 hours. So, this should be remembered of all RTI activities. It should be remembered by everybody that it is within a span of 48 hours. Suppose a pertinent question is that, is pension matters of a particular pensioners, is it taken into life and liberty? Is pension matters relating to any pensioners? Is it taken under life and liberty? I am inviting questions for that a pension matters. The Supreme Court and the CIC guideline is that pension matters is an urgent matter. It relates to right to life. So, the pension matters, anybody, his pension is struck up, he is not getting his livelihood. He is not getting money to earn his livelihood. It's a very serious matter from the part of life and liberty. So CIC has given a decision that pension matters relating to this is also a matter to reckon with, is an urgent matter relating to life and liberty. I will come out with different Supreme Court and the CIC judgments in regards to that. Then comes, last but not the least, is the security and intelligence agencies. That is, time span is 45 days. What does it mean? What does it mean? Can anyone give light on this particular affair? What does it mean, security and intelligence agencies, 45 days? Now, the question is that we have got different paramilitary and military forces in our country. Suppose the questions of, we have got different paramilitary forces, say like BSF, ITBP, CISF, CRPF, NSG, National Security Guards, different intelligence agencies like RAW, CBI, and information agencies working in the country, internally and externally. So there are different agencies as per Schedule 2 of RTI. In these sections, there are large number of security agencies and the intelligence agencies. These intelligence agencies are generally exempted from giving the information to anybody. They are at liberty. They will not be able to give the information. They are debarred. There is strong embargo of giving the information. Information they will not give. They will not share the information. So, you gentlemen must have to know that the things which is relating to human rights and the things which is related to pertaining to corruption, in these two pertinent matters, the information will have to be given by them. They are bound to give the information, and that information will be given by the authority within a span of 45 days. Take the case of human rights in northeast states, human rights violations of the people of the paramilitary forces in regards to corruptions and the human rights in Kashmir or in any other place. If there is any violation of the human rights activity, if there is any corruption by the security forces in relating to these matters, they are bound to give the information to the authority. To the authority means to the appellant. If he is asking for human rights violation in relation to security and intelligence agencies, the authority is bound. The PIO of the concerned department is bound to give the information. So these are the principles. Now, after giving the information, before giving the information, they will have to simply get the permission from the CIC. This is obligatory, and they will get the permission and the information to be given to them. Next. Then exemptions. This is a very important thing. Exemptions, I am coming down to the important part. Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information, disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, economic interest of the state, the relation to the foreign state, and incitements of an offense. Now, have you got that particular thing? Notwithstanding anything, information, disclosure of which is prejudicially affect the sovereignty and integrity. Anything related to the sovereignty and integrity of the country, security and strategic interest, the scientific and economic interest of the state, relation to the foreign state, and lead to incitement of an offense. These are the very important principles you have to know. This is the first principles of RTI. That means anything which is related to the safety and security. What is the safety and security? A country is regarded as safe and secure because if its borders are safe. A country is regarded as safe and secure if there is any internal peace, restoration of internal peace and tranquility in the country. So, if there is a border deployment, suppose we have got Sino-Indian border, India-Burma border, India-Bangladesh border, and India-Pakistan border. So we are sharing the border. Will we be able to share this information of our deployment of the security forces deployed there to the common people? Or if any citizens ask that how many persons are deployed in the border area of Indo-Pakistan border, or in Sino-Indian borders in the northeast region, will you be able to share this information to them? No. This is a very important thing. In regards to the security, sovereignty of the country, we cannot compromise. So there is a sections. Similar is the strategic interest, where we have got the nuclear installations or any important programs of the government which is related to our defense. Shall we be able to share this with the common citizens? No. Even if it is public interest, we cannot share the information to them. The scientific and economic interest of the state. Suppose we have got ISRO and we will make structures of the ISRO. We have made the structure of the ISRO, or any nuclear installations we have kept anywhere. Are we going to share the information to others? No. With no any country, with no any people, we cannot share this information. Now, last but not the least, foreign state. If there is any relation, we have got Indo-Soviet treaty, Indo-American treaty. This treaty has got some restrictions, has some preoccupations. This information cannot be said. And the last one is the incitement of the offense. Anything which is inciting an offense of communal violence, fomenting safety and security of the country, anything relating to destabilize the country, which is ultimately results in riot or communal violence, we are not going to separate, we are share the information. So these are the complete restrictions under Section 8, Clause 1, under Section 8, Clause 1, Subclause A, complete restrictions. Second, information which has been expressly forbidden to be published by the court of law or tribunal and disclosure of which may constitute contempt of the court. So anything, I am briefly, time is very short. There are any things which are to be described also, but at the same time I am concising it. Anything relating to contempt of the court cannot be disclosed. This is not only contempt of the court, but also in the tribunal also. The disclosure of these things are not to be disclosed, but expressly forbidden. The court, when they made it completely forbidden, you cannot disclose the information. But the court has not made anything forbidden. It is in public domain. The information can be shared. I will come out with the Supreme Court ruling for that. The third one, a very important thing, information, the disclosure of which would cause a breach of privilege of parliament or the state legislatures. So anything breaching the parliamentary privilege or anything breaching the state privilege will not be shared. What are the things? What do you mean by parliamentary privilege and the state privilege? Can anyone say to this in my chat box? What is parliamentary privilege or the state legislatures? Privilege of relating to state legislation. This is very important. You should have to know. We railway peoples are generally restricted our information system in only RTI matters for information and counter information. But these things are the pertinent questions sometimes comes to you. Sometimes you have to answer these questions also in relation to our RTI matters. The thing is that what is breach of parliament? Suppose a team of press has gone to the parliament, or a team of people, of media people has gone to the parliament, and there is a parliamentary debate. There is aspersions, there is interactions, counter questions and interaction. There are so many problems, criticize and counter criticism. There is vehement argument in regards to two parties, party A and party B and party C. There is stick quarreling in the parliament. And these parliamentary procedural matters are the privilege of the parliament. Any press team or any team or any media team or any person cannot disclose it openly to the newspaper. This is a parliamentary privilege. Similar is the case of legislatures also. The argument, counter-argument, criticism, counter-criticism. It should be restricted to that particular legislatures only. It should not be open to the common people. It should not be published in the press or any other media. So these are very complete restrictions. There is complete embargo. Because the country's questions and reputation in this particular matter is involved. So you cannot disclose. The fourth one related to all of you railwaymen and other persons who are joining here must have to remember, information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive positions of a third party unless the competent authority is satisfied for the larger public's interest warrants the disclosure of such information. the pertinent factor in this particular question is that information relating to commercial confidence, information relating to trade secret, information related to intellectual property, the disclosure will harm the competitive position of the third party. So these types of information cannot be shared. But there is a clause in the fourth one that for public interest, later on we will come, greater public interest, the information can be shared. I am giving one example. These things, suppose railway has got some business agreements. Show me the last one, the D. Suppose railway has got some business agreements with a corporate organization, and that information between the railway and that corporate organization is strictly a secret, prohibited. That information cannot be given because it is the business information, the commercial confidence and the trade secrets is involved there. So this information cannot be given. Suppose the internal market strategy, internal marketing strategy, railway has chalked out. That information, if anybody desires to get, that information cannot be given. So these are the essential trade secrets, essential commercial confidence which cannot be given. Suppose an organization named, what is the name of the organization? Yes, KFC is making a fried chicken. This information is a secret information, and this is a popular fried chicken served to the public in general, and they are getting that in the market. But that recipe, if that recipe is given and that recipe is open by the open to the common people, then that secret is open. So that by dint of that trade secret, he is earning money, he is getting a commercial gain, he is making marketing. That information cannot be given to anybody. So these are the most important paraphernalia. I will come later on. There are so many plethora of information in regards to trade secret, trade confidence. The information cannot be given. These are the intellectual properties also, that because he has made a cuisine, and that cuisine should not be open to anybody. E, information available to a person in his fiduciary relationship unless competent authority is satisfied that the larger public interest warrants the disclosure for such information. Now, gentlemen, I would like to mention one thing, that they are telling about public interest and the larger public interest. Here the information is based on fiduciary relationship. The information, as I am telling you, fiduciary relationship is based on trust, Suppose doctor-patient relationship is based on completely trust. Another information is bankers and customers relationships. This is also fiduciary relationship, it is completely based on trust. Lawyers and client relationships. This is also a very significant factor that is based on fiduciary relationship. This information are restricted to be shared. There is an embargo that you cannot share generally the information. But the questions, the second pertinent questions is very important, that the larger public interest, that the disclosure of such information can be accessed or can be given. So for the larger public interest, if the competent authority thinks that this information is relating to a very significant factor for public interest, that for the interest of the public, that interest can be, information can be given. Now here is an example I am giving, is public interest. Can anybody share what is public interest or the ledger? We are telling that it is public interest, it is general public interest, it is greater public interest. What is the public interest? Now in this RTI, in the entire chapter, if you browse the entire chapter, you will not be able to find that there is larger public interest or the public interest. What generally the public interest means? Public interest means the societal benefits. Generally, you railway people must have to know the societal benefits. Information which is related with societal benefits. Societal benefits means, suppose, human rights violation. It is public interest. If there is a human rights violation, then it will be added in public interest. Then it is a health need, then it is also connected with public interest. Then it is environmental need, that is a public interest. If any factory will have to be built and that factory is in a place where the public will be affected, so there, from the environmental point of view, for the greater public interest, that information, if it is entered between the two parties, information can be shared because public interest is being affected. So these are the public interests. Suppose public accountability, where the public is accountable. If any thing is happening, suppose a Union Carbide factory that has been built in Bhopal, and if that Union Carbide factory is going to be built there, or any other factory which is against the directions of environment, if is going to be built there, and if it is a relationship, it is a close relationship, fiduciary relationship between two parties, and that relationship should be disclosed by the complainant authority if it is affects the health of the public. So this is a very pertinent section. Now, time is very short, therefore I am making it shorter. Information received in confidence from foreign government. As I have already told, if the two foreign countries are making a bilateral treaty and that bilateral treaty is a confidential and secret documents or regarding defense, regarding stability of the country, regarding the cooperations of technology or the transfer of technology, that information cannot be shared with others. Information, the disclosure of which would endanger the life and physical safety of any person. Remember, I am repeating, you just go through with the line, that is called between the lines, information. That is any kind of information, the disclosure of which would endanger the life or physical safety of any person, and identify the source of information, assistance given in confidence for law enforcement or security purposes. The main cardinal principles, you railway man, you must have to be very, very clear in this particular section G, section 8, clause 1, subclause G. Kindly note that safety of the person, this is the very important word, safety of any person, or identify the source information, assistance given in confidence by the law enforcement agencies and security purposes. Generally what happens in our experiences, and any people, those who are in the railway, they might be knowing all these things. Vigilance check has taken place in a particular place. A vigilance check has taken place in a particular place. During the time of this pre-decoy check and post-decoy check, some information has been collected by an informer. An informer has given such information in that pre-decoy check and the post-decoy check. Can that information be shared with anybody? If anybody is asking for the information that who had given the information, what is the name of that informer, or who has given the source information, is it possible, or are you going to suffice this information to that particular person who has made an application in the RTI? Generally, no. Suppose in the Railway Property Unlawful Possessions Act registered by the RPF, or in the Railway Act, a case has been registered on the basis of the information of an informer. He has given some information. On the basis of that information, huge property has been recovered from a particular place. And if anybody is asking that who has given the information, who was the team, who are the team members who are involved in this particular raid and drive, are you going to give the information to that particular person in regards to RTI? No, definitely no. So the source information, note it, the source information and during the time the informer should inform us information or any other thing relating to that should not be informed. There are so many things. Source information should not be shared with anybody. The vigilance team member's name should not be shared with anybody. The raiding party's name should not be shared with anybody. The informer who has given that information during the pre-decoy check and the post-decoy check should not be informed to anybody. So there is complete restriction because his life safety is involved there. He will be killed for that. So his safety and security of his life is there. So that information cannot be given. Then H is also very important for all railway persons. Kindly remember that section H also. Information which would impede the process of investigation or apprehension and prosecutions of the offenders. The pertinent question, there are three things are there. Information, it is a flow of information generally. Information which relates to investigation. Information which relates to apprehension. Information which relates to prosecutions of the offenders. The three cardinal principles are here involved. So in this connection, you cannot share the information. But generally, many questions can be asked or hurled in this affair. Sir, this is a question that it is not involving our railwayman. It is not connected with our railwayman. It is not a fact in issue. Section 8, clause 1, subclause H. But this is the most basic pillar of our railway, on the basis of which many informations are being gotten. Why? Because this investigation also means the inquiry. First of all, you should know information is coterminous with inquiry. Information in the police investigation is also coterminous, is also similar to that of inquiry. Any vigilance inquiry, any fraudulent inquiry, any DR inquiry, any type of inquiry relating to our department of the railways, it is also related with investigation. So it is a synonymous term. I will come. CIC's judgments and the Supreme Court's judgment, they have delineated it that the information, this type of information relating to investigation is also similar to that of inquiry. So this information should not be shared. During the course of inquiry, during the course of anti-fraud check and inquiry of anti-fraudulent activity, any type of criminal activity, these information, suppose Railway Property Unlawful Possessions Act has been registered and the officer in charge of the Railway Property Unlawful Possession Act is holding the power of the officer in charge of the police station. So when he is having the power of the officer in charge of the police station, he is not bound to share the information during the time of investigation of a particular case. Similarly, under Railway Act also, under section 143, illegal transactions of property, under sections 160, clause 2, breaking the level crossing gate, and there are other sections also in the non-billable sections where the railway RPF peoples are doing the inquiry or investigation as the case may be, and that information during the pendency of investigation or the inquiry cannot be shared to anybody. If anybody is asking who are the members of the RPF team, who are the members, what is the names of the source information, from where the source has been engaged, or what is the name of the source informer, these things cannot be given because it's a matter of investigation and his life is at risk. Then section I, it is though not related with our railway, but you should have a clear idea in regards to that. What is that? Cabinet papers, including records of deliberations of the Council of Ministers, secretaries and other officers, provided that the decisions of the Council of Ministers, the reasons thereof, and the materials on the basis of which the decisions are taken shall be made public after the decisions has been taken and the matter is completed over. So the cabinet papers, generally during the times of the records, the deliberation, this information cannot be given, and after the end of the cabinet meetings, after the cabinet papers duty and responsibility is over, then the material can be given in public domain, provided they have in the last concluding stage they have given, provided further those matters which is under the exemption specified in this section shall not be given. That means section 8 clause 1, there are 10 exemptions. If the cabinet papers comes under this, safety and security, the parliamentary papers or the contempt of the court, these papers should not be given. So this is the in a nutshell. Next. Information which relates to personal information, the disclosure section 8 clause 1 subclause J. This is a very important thing. Information which relates to personal information, the disclosure of which has not relationship with any public activity or interest, or which would cause unwarranted invasion of privacy, that is right to privacy of the individual, unless the central public information officer or the state public information officer or the appellate authority, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information. Can anybody describe that important sections in my chat box? Give it in my chat box. What is written here? What is written here? Under section 8 clause 1 subclause J, this is a very important thing, that generally the information, personal information, which is related to two parties, that information cannot be given because it affects the right to privacy, the invasions of the privacy. So it is the individual to individual relationship, that personal relationship, that cannot be. Suppose husband-wife relationship, it is completely a personal relationship, and this relationship is exclusive. If that information in regards to this matter is suffice to others, then there will be no right to privacy. So right to privacy must have to be attended to. So there is restrictions. But here, how the RTI is transparent, you see, they have included a clause. Rightly they have, this is the democratic clause. This is a very important clause, that for the public interest, they have told the larger public interest justifies the disclosure of such information. Suppose a doctor's-patient's relationship is there, and the patient is having the disease of a secret disease, that is HIV, and that information, if it is given, it will affect the doctor's-patient relation. Doctors cannot give that information to anybody for the larger public interest. Anybody can be larger public. But the questions the pertinent questions also arises that if that information, it is an agreement between doctors and patient, and that information cannot be given, it is completely restricted. And if it is given by the doctors without the permissions of that particular agreement, then this is a violation of rules. So right to privacy is affected generally. Of course, there are some other important pertinent questions. Suppose lawyer has given an opinion to the railway. A lawyer's opinion in the records has been given to the railway. And this information, if it is shared with others, it will affect. There is a public, and there is no public interest which is affected. What is the public interest there? Nothing. But if that it is affecting the larger public interest, but lawyer has given the opinion, defined the rules and regulations, and it is a closer relationship, For the larger public interest, that informations can be given. So there are many things which is affecting the right of privacy. Generally, this information cannot be given. These are individual personal relationship. Generally, should not be given. For the larger public interest, that provided can be given. Then Section 8, Clause 2, notwithstanding anything in the Official Secrets Act, nor any of the exemptions permissible in accordance with subsection 1, the public authority may allow access to information in public interest or disclosure outweighs the learned harm of the public interest. This is also a Section 8, Clause 2, that generally on Official Secrets Act, information cannot be given. But if it is affecting the public interest, then for the greater public interest, that informations can be given. Subject to the provision of A, C, and I of subsection 1, any information relating to any occurrence, event, or matter which has taken place, occurred, or happened 20 years before the date on which any request is made under this section shall be provided to any person making the interest under this act. See this act, how benevolent, how magnanimous this act is. In no other act, perhaps, these things, this act has been, the statutory provisions has been provided. Only in the RTI Act, which is a democratic process of government, this act has given this power. What is the power under Section 8, Clause 3? That the information which has been, the thing which has happened 20 years earlier, the things which has happened 20 years earlier will have to be given to you. Will be given 20 years earlier. The thing has happened 20 years earlier, and you are asking for information under Section 7, Clause 1 in regards to the information. You are disposing the information. If anybody is asking for the information under Section 6, then under Section 7, you are bound to give the information. Though the information has happened 20 years earlier, so RTI has got retrospective effect. Retrospective effect from the previous effect. How the magnanimous, democratic, and benevolent this act is there. So this is a good provisions under RTI. Then we will come, gentlemen, we will take 5 minutes break, and after 5 minutes break, we will be coming again. We will be coming to you at 4:30 sharp, and we will be coming again.
उसमें कुछ करना नहीं कमेटी को, उसमें बस आपको लेटर निकाल देना है। अभी किसे निकाला है तो करेंगे। ये आम की लिस्ट हेडक्वार्टर निकाला दो लाइन में लेटर हेडक्वार्टर निकाला है, जैसे निकाला है कि कोई गेट मीटिंग और पर्सनल मीटिंग का नहीं लिखता, दो लाइन से हेडक्वार्टर निकाला है, इतना ही करना है। वो सबसे पहले नाम आपकी लिस्ट नहीं निकालेगा, ठीक है? वो लिस्ट बोलना है, आप हेडक्वार्टर भेज दो लिस्ट होना है। हेडक्वार्टर से हम तो बोले नहीं, देखा जाएगा। हेडक्वार्टर निकाल, हेडक्वार्टर जाके निकाल दिया, मीटिंग करना होती निकाल, ठीक है ना? हेडक्वार्टर निकाल ही दिया उसको। क्या मैं हमको दे रहा था मीटिंग करने, तो लेटर दे देंगे हमारा मीटिंग करने, तो गेट मीटिंग करने वो ऑफिस में मिलने आना था, हमारा से भी किया आना है ना। बाकी बिल्कुल नहीं, क्या हेडक्वार्टर से निकाल दिया आप।
Welcome back. Now, section 9. I am coming to section 9, further exemptions. These are all the exemption sections. You should have to be well acquainted with these exemption sections. As I have already mentioned you, section 8, clause 1, there are 10 sections which are exempted. And in these exemption sections, section 8, clause D, section 8, clause E, and section 8, clause J, greater public interest is involved. And here, as far as the section 9 is concerned, it is also a very important section. I am reading it. Without prejudice to the provisions of section 8, a public information officer or the state public information officer, as the case may be, reject a request for information where such a request for providing access would involve an infringement of copyright subsisting in a person other than the state. That means anything which is an infringement upon the copyright, that information cannot be given. Simply, you should have to know that the copyright in anything which is related to infringement of copyright, that information cannot be given to anybody. Next. Now, this is a picture I have delineated for your understanding that public PIO and appellate authorities. Who are the PIOs? As I have already told you. APIOs, as I have already told you, and the at the zonal level, at the divisional levels, at the zonal levels, and the railway boards level. So these are the very important thing. At the divisional level, the PIO is the senior DPO or the senior DCM or any other branch officer, senior branch officers at the divisional level, and being aggrieved with the order of the PIO, anybody will go to the appellate authority. The first appellate authority, that is CPIO, Chief Public Information Officer. He is the first appellate authority. Here and being aggrieved with the first appellate authority, he will go to the second appellate authority, that is CIC. CIC is the apex body. So these are the delineation. Similarly, at the zonals and the railway boards level, the PIO is the deputy GM, and the first appellate authority is the GM, AGM, and the CIC is the Chief Information Officer, is the second appellate authority. Here in the second appellate authority is the apex body of the RTI. The first appellate authority is the here is the AGM, and the second appellate authority is DGM. Similarly, in the railway boards level, the PIO and the first appellate authority has been delineated. Nothing to be described here. You will be able to understand by reading it. Next, implementations of the provisions of the RTI Act. Gentlemen, this is a very important letter given from the Railway Board. In this letter, the gist of the letter is that the standard of the RTI applications is day after day is stated to be very, very casual, and this standard is not up to the mark. That is why from the Railway Board's level, instructions has been given that if you are giving the RTI application, particularly from divisional level and the zonal level, these senior officers, that is GM and the DRM, will have to look into this matter, the standard of that application, that and the time frame, within the timeline the application should go. This is the gist of the application, nothing to be described here. These are the similar to that, so it is not to be described here. Then time frame, then no, this is another previous one. This is the quality of the applications, where they have general managers and the DRM will have to be looked into. The PIO, which is who are giving the application, it should be within a time framework, and the standard of application should be checked or should be scrutinized by at the divisional level by the DRM, and at the zonal level by the GM. Next, this is time frame for appeal. This is also important for all the RTI activists and those who are just participating in this particular webinar. PIO, the normal disposal for appeal on the part of PIO is 30 days, and first appeal, it will go to DRM or AGM, which will be within a span of 90 days. So disposal time of the appeal on the parts of the first appeal is 90 days, and then it will go to CIC. But here, gentlemen, I would like to say 30 days for the PIO for the disposal of appeal, 90 days for the for the first appeal on the part of ADRM, or that is the Chief Public Information Officer, as the case may be. And if it goes to the CIC, can anybody tell that what is the time framework of the CICs for disposal of appeal? Here we are mentioning that the time frames of the disposal of appeal is 30 days on the part of PIO. The time framework for the disposals of the first appeal is 90 days on the parts of time frame was disposal of appeal. And there is no time frame on the part of the CIC. Within how many days the time, what is the time frame for the disposal of appeal on the part of CIC? There is no time framework. That I wanted to mention you. Quantum of penalties. This is also a very important thing. The penalty of rupees 250 per day up to 25,000. Remember, the lowest penalty on the part of the PIO is 250 days, 250 per day, and highest penalty is 25 days. So the penalty will be charged under section 20. Anybody is defaulting in giving the information or rejecting the information abruptly, he will be charged with a penalty of rupees 250 per day up to 25,000. The second one is the very stringent punishment, stringent imposition of penalty. Disciplinary action can also be recommended against the PIO. You see how serious in this particular RTI Act is. There, disciplinary actions have been imposed on the part of the PIO. And deemed PIO, if the assistance has been sought from other officer under section 5 clause 4, then for any contravention delay, other officials shall be treated as deemed PIO. So deemed PIO will be taken at par with the PIO under section 5 clause 4. He is not exempted for that. Now I am giving you some verdict of the High Courts and the Supreme Court. Kindly bear with me and kindly go through this particular case. Medical expenses of the judges cannot be revealed under RTI. The quintessential principle of this particular judgment is that the judges' medical expenses cannot be taken into consideration. They are exempted under RTI. I am going through with the concluding section. Supreme Court of India in Subhash Chandra Agarwal versus Registered General Supreme Court of India held that the medical expenses of the judges are not qualified to come within the ambit of the RTI Act. The judges' expenses, medical expenses of the judges will not come under the ambit of the RTI Act. The Apex Court rejected the appeal against the Delhi High Court decision, which has held that the information about the doctor's visit expenses of the judges and their families cannot be revealed, being the personal information exempted under the disclosure under 8 clause 1 subclause J. What is 8 clause 1 subclause J? That is personal information, and that personal information should not be given. Next. And this is a CCTV. Both the judgments are there, both the informations are there. You go through with that whether the CCTV information should be given, and here in the second, whether that information can be restricted. In the first, during the times of CCTV is an information, and if it is in the domain of information, that information can be given for public interest. And the second one is that the CCTV footage and exemptions of provision. This is very pertinent. A study of the CIC decisions indicates, I am going through the second part that is important. Footage can be withheld under the exemption provision of RTI. In the first, CCTV information is given. In the second, CCTV information should not be given for the safety and security of the country, for the sovereignty of the country. Both of them is applicable in case-to-case basis. You go through with the case and determine what is to be done and what is not to be done. But the CCTV, which is in public domain for public interest, can be given. Next, Section 23, power of the jurisdictions of the court. Section 23 of the Act cannot erode the jurisdictions given under Article 26 to the High Court and under 32 of the Supreme Court. No court shall entertain. They have used the word shall, not will or may. They have used the word shall entertain any suit, application or other proceeding in respects of any order made under this Act, and no such order shall be called in question otherwise than by way of appeal, provided under Section 19 of the Act. In other words, the jurisdictions of the court has been ousted by the express language. Nevertheless, it is a settled principle of law that despite such exclusion, the extraordinary jurisdictions of the High Court and the Supreme Court in terms of Article 226 and 32 of the Constitution respectively cannot be divested. It is a jurisdiction incapable of being eroded or taken away by the exercise of legislative powers, being an important facet of the basic structure of the Constitution. It is Namit Sharma versus Union of India, WP number 210 of 22. Now, this is a very important question. As I have already told, under Section 23, there is bar of the jurisdictions of the court. No court can call in question on the decision of the CIC. If a decision is given by the CIC is just like a court, and at the same time that decisions cannot be challenged. Now, in the second paragraph, they have already told that being aggrieved with the order of the CIC, we can go to the High Court and the Supreme Court. So you are finding a contradiction. No, this is not a contradiction. It is the rights of the people. We have right to life. We have right to life under Section 21 of the Constitution. And Section 121 of the Constitution, if anybody's right to life is affected, it is a fundamental right, and he can challenge that right in High Court and the Supreme Court. Under High Court, we can file writ under Section 226, and in the Supreme Court, we can file writ under Section 32 of the Constitution. Gentlemen, we have got right like habeas corpus, quo warranto, certiorari, mandamus, and prohibition. These are the important writ petitions being filed in the High Court and the Supreme Court. Absolutely on the basis of this question, the right to life is enhanced and protected. So, if any CIC decisions is given against the party, and the party being aggrieved with the impugned order, is at liberty to go to High Court and the Supreme Court for the redressals of his grievances. This is the cardinal principle. So High Court, the CIC cannot bar, or this RTI cannot bar the people's rights to go to the High Court. Section 8, Clause 1, Subclause G, exemptions to apply for intellectual property in certain cases. Exemptions under Section 8, Clause 1, Subclause D is available only in regard to intellectual property, disclosure of which would harm the competitive positions of any third party. The term intellectual property refers to a category of intangible rights protecting commercially valuable products of human intellect, comprising primarily the trademark, the copyright and the patent right, as also the trade rights, publicity rights, the moral rights, rights against the unfair questions, question papers, instructions regarding evaluations and the solutions to the questions or model answers which are furnished to the examiners and moderators in connection with the evaluations of answer scripts are literally works which are the product of human intellect and therefore subject to copyright. So anything which is violating the copyright cannot be given. So questions paper, evaluations, answer sheets, these are the things These are the important Copyrights Act should not be given. Section 8, exemptions, mandatory as well as discretionary. Here, this section 8 has been delineated into two parts. One is mandatory and another is discretionary. What is mandatory? Section 8 clause 1 subclause A, Section 8 clause 1 subclause B, Section 8 clause 1 subclause C, Section 8 clause 1 subclause F, and Section 8 clause 1 subclause G, and Section 8 clause 1 subclause A. 1, 2, 3, 4, 5, and 6. In this 6th Act, you have got the exclusive rights. That exclusive rights cannot be violated. But Section 8 clause 1 subclause D, subclause 8 clause 1 subclause E, and Section 8 clause 1 subclause J, that is fiduciary relationship, trade relations, trade secrets, and that is personal relationship. These cats, for the greater public interest, this can be disclosed. This is the cardinal principle. So, these restrictions, exemption clause under RTI 8, which are 10 in numbers, they have delineated into two parts. That is mandatory and another is discretionary. Optimum use of limited fiscal resources. This is also a very important thing. I am going through with the judgment part. The Commission, in full agreement with the decisions of the CPIO and API Appellate Authority, the information sought is so voluminous, covering practically the entire gamut of the functioning of the company. It would be definitely cause a lot of pressures on the company, and the applicant is at liberty to ask for specific information which would not cause enormous times and efforts to collect the information which is related with voluminous information, the large information, voluminous information. That information cannot be given. They could be either specifically asked for the specific information, what you want, what specifically you want that information to be collected and furnished. Next. Disclosure of information in DR case after completion of inquiry. Now, the gist of this particular thing is that during the pendency of the DR case, you cannot give the information with anybody. You cannot share the information. If any applicant is asking for the information in regard to the DR which is pending, then information cannot be given. After the completions of the DR, then DR files information can be given. This is the gist. You go through with that, you will be able to understand that. Next. As I have already told you, gentlemen, this is a pertinent information. In some of the matters you are being asked, the RTI activists must have to be careful. Note this judgment. The railway clarified that 2 stages of DR inquiry was over and the party already has gone to CAT over the issue. The railway also informed that the commission that the document, if supplied, would hamper the investigation. Moreover, the report contained the names and informer, the disclosure which are likely to bring harm to this person. The CIC directed the respondent to supply the information of the applicant after concealing the names of the informer. As I have already told, that the names of the informer for the safety and security of that particular investigation cannot be given. Here they have delineated that during the DR or during any type of vigilance inquiry, when the pre-decoy, post-decoy checks are taking place, then information can be given only, but the name of the informer should not be given. There is strict embargo. Information about the members of the vigilance team may not be disclosed. This is also, I have mentioned that the vigilance team, who led that vigilance team, who are the informer, who gave the source information, where is the source, these types of information, there is close embargo under section 8 clause 1 subclause A, and you cannot give this information. personal information and secrecy under Section 8, Clause 1. A case of wife of railway employee. It is a case of wife of railway employee, very interesting. The medical report relating to the wife of a railway employee was shot. Denial of disclosure to third person other than the husband of the lady was as personal information. No objection from the husband. Again denied by the CPO, First Appellate Authority. There you see that the medical report of that particular lady should not be given. It is a personal information relating to right to privacy. Next, secrecy of the medical bills and the prescriptions. Here it is related to the medical people, that the medical bills and the prescriptions. Prescriptions is a public document, but medical bill is a personal document. So we should have to use Section 10. What is Section 10? There are some information where the information can be given under RTI, but some information which are completely restricted not to give that information. Here, this is the information that the medical ailment of a person is contained in prescriptions. That information is a personal information. You cannot give that. But the medical bill is under public domain, because in the hospital, in the registers, in others, it is there. So you can give that information. So here we have used Section 10. What is Section 10? Right of severability. That means curtailment. Some information can be given, some information cannot be given. That is under Section 10. That is Section 9, gentlemen. Yes. Information regarding court case not to be denied unless specifically forbidden by the court. This is also a pertinent thing to mention here, that the court case, all court case, you people in RTI, we are just having a look, that after examining that, you are telling that this is court case and information is relating to court sub judice, it cannot be given. No, gentlemen. Here they have mentioned specifically that what the court has not made it forbidden. Court has not, that this information cannot be given. If the court has told that the information cannot be given, that is a forbidden information, then you cannot give. But the court, if the court has not given that instruction, then you are at liberty to give. You see the case, in the case of Shri Rajesh Suptakar and CPIO South Central Railway, it's a South Central Railway case, appeal number so and so, 17th October 2008. The appellant's information on 4 courts relating to payment of the wages and regularizations of the licensed porters in ACC Railway Nagpur. Yes, information can be disclosed which has not been forbidden by the court. Court, the last line, that not been, which the court has not forbidden any information, that information can be given. ACR, now no secrecy. As you are well aware, those who are dealing with the ACR, nothing to be told. ACR should be disclosed. And there is this is in connections with the transparency in public administration, which requires transparency. Whatever you are writing down in the ACR, suppose you are writing poor, writing average, writing fair, good and very good. Whatever is contained in the ACR, you should have to give it, you should have to communicate. That is the transparency. Meaning of investigation under RTI, this is a pertinent sections. Kindly note it that the word investigation, as I have already told you, used in Section 8, Clause 1, Subclause H, includes all departmental inquiries. You write down, all departmental inquiries are related to investigation. All verifications of records are related to investigation. Assessment and so, which may be ordered in specific cases. Such inquiry should be taken as completed when the disciplinary authority finally decides the innocence or guilt of the person. So, during the pendency of the inquiry, information cannot be given. But after the inquiry is over, after inquiry is finalized, the information can be given. departmental or vigilance inquiry, and the RTI. This is also very important sections to reckon with. In this case, a disciplinary proceedings was initiated against the appellant under the service conduct rules. The applicant has requested for information relating to disciplinary proceeding. It was denied by PIO under section 8 clause 1 subclause H, and CIC decided that since the applicant is entitled to get the copy under the provisions of the conduct rules to prove his innocence, therefore he is advised that the appellant should submit a list of the required information before the competent authority, and if the required information or the documents are not supplied to him, he only can approach to CIC. This is a very important judgment to reckon with. Here, what they have told, an applicant, he is a party to the DAR. If he is a party and he is asking for information under RTI, that information can be given to him without, until and unless, if the information is not given to this party, the right to natural rule, the natural rules and regulations, the natural justice will be violated. What is your actus prudence? What your mind says, that a party who is asking for the information for his own and he is related with the DR case, should we not give the information? How that party will give the reply to that particular thing? Therefore, the most important pertinent questions in this particular affair is that the party should be sufficed with the information what he has asked to give his reply. As I have already told that during the time of vigilance inquiry, information should not be given. Tendency. But here the party himself is involved in this particular, and he is asking from RTI that at the same time I should be sufficed with the information to give my reply. So that information is mandatorily to be given to that. इन्वॉल्व है, उस पार्टी अगर इंफॉर्मेशन मांगता है अपने के लिए, अपना लिए, वो इंफॉर्मेशन आप देने के लिए बाध्य रहेंगे. नेक्स्ट, नो क्रिएशन ऑफ इंफॉर्मेशन. Here the ruling is very clear that whatever is in your public domain, what the information which is in the public domain, which is in the public jurisdiction or arena, that information can be given by the PIO. The CIC's decision is that transfer order was issued in public interest for which nothing was available. Since nothing was available, the same cannot be created as such. Requested information did not come under the definitions of informations under section 12. What is related, what is available in the public domain, that information can be given. That means जो इंफॉर्मेशन पब्लिक डोमेन में आधारित है, जहां पर इंफॉर्मेशन है, जो इंफॉर्मेशन आपके पास है, आप वही इंफॉर्मेशन देंगे. आप इस सेक्शन 2F के दौरान आप वही इंफॉर्मेशन देंगे. ये इंफॉर्मेशन में आप नया इंफॉर्मेशन को क्रिएट नहीं करेंगे. नो पेनल्टी फॉर बोनाफाइड मिस्टेक्स. It will be sections, bona fide mistake. For bona fide mistake, records have to be preserved for longer period. Yes. What is here? RTI is not seeking answers and questions papers under section 2J. Here it is also very pertinent. First of all, I would like to say that bona fide mistakes, if you are making if any RTI personnel or the PIO or the RTI activist is making some bona fide mistakes, that means the inadvertently that mistakes has been done and he has confessed that mistake, that I have made that mistakes and it is not within my domain. So that inadvertent mistakes can be condoned. RTI is not for seeking answers and asking questions. This is also a pertinent question. You cannot seek answers and asking questions. RTI is not the platform. Here it has been delineated. I am going through as to who is responsible for a delay in dispatch of the letters from the office of the commission, you are asking a question. That questions where RTI personnel is not bound to answer. Secondly, as to why paragraph 2 and paragraph 3 of the rejoinder submitted by him in his appeal petition were not taken into account while deciding the matter. You cannot ask such questions to the RTI personnel who is not bound to answer all these things. That is why RTI is not seeking answers and questions, asking questions under section 2J. You go through it that year. This is the CIC's judgment. Motive of the person in seeking the information is not to be explored under section 2. Here it is, the main thing is that you cannot ask for the motive of the person. What is the motive of the person for asking the question? Where the questions is under the applicant is at liberty to ask you the RTI questions and you are bound to answer. But you cannot, the PIO cannot ask that gentleman, ask that fellow that what is your motive of asking these questions. You cannot ask. It is strictly barred there. Next. Reasons for rejections of the request for information may be clearly provided. Here it is mandatory for every personnel. I am directly coming to the judgment part that when you are answering a question, rejecting the questions of an applicant, then you have to give the cogent answer. You need not have to give only the sections that it is bar under section so and so, and we are not bound to give the answer, or it is barred under section. Only mentioning these sections and not giving the cogent reason, it will invite stringent action, will invite criticism. So you have to give the justification and the ground. Ground and justification must have to be given along with the section. And it is barred under section so and so because you have asked certain questions and you have to give the answer. So this is very important. Documents pertaining to the ongoing CBI case. Now, gentlemen, during the pendency of the CBI case, you cannot give the answer. But there are some restrictions in the pendency of the CBI case, which is sub judice. But here it is something different, ruled that since the charge sheet has already been submitted, after the submissions of the charge sheet, it goes to the court. And if it is going to the court, CBI has opened all these things. There is no restrictions in the investigation. We have submitted the charge sheet, the final report. So there stands no bar under section 8 clause 1 subclause E and 8 subclause 8 that it is barred on investigation or a fiduciary relation. You can give this. Copy of the CBI report, it is similar to that of the previous judgment, so you should have to go through this judgment. You will be able to understand. This is the similar type of judgment under RTI. Copies of the confidential report. Then copies of the confidential report. The CIC mandated for disclosure of information sought, and the commission referred to the full bench decisions of the CIC passed over dated 19/2/2009, appeal number so and so, concerning disclosure of ACR, and also referred to the Supreme Court decisions in Devdutt versus Union of India, and decided that the complete information sought by the appellant, meaning certified copies of the ACR, shall be provided. Though copies of the confidential I have already given. Information relating to empanelment of the officers as provided by the ACC for promotion to the higher post. Here also I have told that certain information should not be given. Certain information relating to empanelment of the officers as approved by the ACC for promotion to the higher post. Judgment is that the commission in its decision stated that the empanelment process and approved the list of the empanelment officers are by no stretch of imagination personal information of any third party. Empanelment is a system established by the government to make the informed choices about appropriate officers to man the higher position, and thus it is related to governance. The Commission has overruled the claim of fiduciary relation and rejected the application of exemptions under Section 8, Clause 1. Para 21 of the decision, Commission mentioned that the government has removed all secrecy from the approved panel of IAS and IPS officers, and according to panel of IRS officers should also follow the same policy. Commission accordingly ordered for the disclosure of information. Here, information cannot be disclosed. This embargo has been lifted because the recruitment has already taken place. The decisions of the Commission is there. Frivolous application not to be entertained. This is by dint of the mayor writing frivolous application. Application which is frivolous or frivolously given, these information cannot be entertained. This is the gist of this CA. The CIC held asking all records regarding various services and categories of the staff in the railways only amounts to making a mockery of the act. You cannot make RTI the mockery of the act. Records not available. The records which are weeded out, records which are destroyed as per the rules of the railway board. If you want that information, that cannot be given. The applicant to take up the issue with the department concerned in case he noticed that any record which did not fall under the weeding out rules has been destroyed. So this is the main intention that for records will have to be preserved for a certain amount of time, and after that it will be destroyed. As far as the RTI is concerned, the rule is for 20 years. But as far as the attendance register is concerned, it is lifelong. Throughout the life, it will be preserved for the RTI activists. Now here, according to record retention schedule, the records will be weeded out. Voluminous information. Here, the gist is that the voluminous information should not be given. The record which is voluminous, better you ask the person to come to visit your place, and according to his query of information, he will ask. Section 7, inspection. That is called the inspections of record. Voluminous information of loading and unloading in the yard, it is a voluminous information, and that information cannot be given. You ask the appellant to visit the office and inspections of record, and according to his choice, he will get the information. Application of information, the appellant asks for 20 items of information, each of which related to a different department. So, the applications which is from different department, the applicant asks to put a separate application for each of the items of information, and the respondents reply upheld by the commissions. Yes. So it is the information which is multifarious informations relating to different department. You can ask that you can give separate application to the different department, and the commissions has accepted it. Application of information, it is the commission held that a standard application cannot be mandated. It is to be treated as an acing of processes. Its absence cannot be grounds for rejections of the application. It is incumbent upon the PIO to render reasonable assistance to the person seeking information. So there is no head and first rules of the application which is mandated. But whatever form the application has been asked, you can give the information in that manner. Exemptions from disclosure, commercial activities. This is also important. The applicant asks for details of the franchisees who were given sale rights of SIM card and recharge vouchers, copies of the agreement executed under SIM cards received and sold, and the commission received by them. The commission held that the information pertains to commercial activities of the respondent, upheld that the denial of information under Section 8, Clause 1, Subclause 2. exemptions from disclosure, the rail trouble. This is also Sir Abdul Warish Abdul Ajid Sheikh, Central Solapur. Railway details of the rail trouble by the rail by a third person, short from railways. The commission observed that the information is personal information, hence exempt. So rail trouble information understood. Further, the information is not available as the concerned reservation forms and charts open prior to 6 months and been destroyed. This is very important. Sometimes it is being asked to give evidence in the court case. So the information, the reservation chart or the trouble chart, which is maintained for 6 months and after that it is destroyed, how that information can be given. So this is a delineation. Kindly go through with that. This is Council of Scientific and Industrial. This is not related directly to your, this is related to intellectual property and the third party. So you go through with this. Husband pension papers. Sometimes this is a pertinent questions on the part of the railway. The commissions observe that the appellant is seeking information in respect to his husband pension papers, which cannot be given his consent. The consent of the husband is mandatory because it is a secret document and that information is between railway and that particular employee. So information should be taken from him. Reasons for non-inclusions of promotions. This is a promotional matter. Kindly go through with it. Nothing very important. Service matters. Proceedings of the selection committee. The commissions observe that the certified copies of the proceedings of the selection committee are completely in public domain. Denial under Section 8 clause not tenable as the selection process are already over. The PIO is directed to supply. So after the selection process, it is under the domain of the promotion things are the domain under the selection committee, and that information can be given. Only 10 appellants applying doctrine of severability as provided in Section 10 clause 2. Separately, you should have to give marks awarded to candidates. The commissions accepted the CPIO. The appellant asked for the information relating to marks awarded to the candidates in the departmental examination. The CPIO refused to furnish the information under Section 8 clause 1, holding that the relevant information cannot be disclosed to parties other than the candidates. The commission accepted. Yes, it is related to a personal information and that information cannot be given. Marks obtained is nullified in examinations. This is also a similar type of judgment. Go through with that. Important judgment of the CIC in regards to tender contracts. Now, gentlemen, minutes of the tender committee is very important. Time is running up. Therefore, basically, you have to understand that the information was denied to him under Section 8 clause 1 subclause A of RTI 2005, being information which would prejudice the economic interest of the state. In regards to the economic interest of the state, that is Section 8 clause 1 subclause A, if it is related to the economic interest of the country, that information cannot be given. Minutes of the tender committee. In the case of Shri Arun Kumar versus such and such, the applicant sought the information pertaining to the tender committee's recommendations of award to work such and such company, as well as noting and correspondence from the files and pertaining to the object of the road over bridge of Dhola Kuan. The information was denied under him under Section 8 clause 1. This is also a pertinent question. It is related to the safety and security of that particular bridge and security, therefore information here. CIC directed that the tender committee minutes asked for him in the application dated ATO be made available to the appellant. However, the commissions agreed that the railways disclosure of the file noting and correspondence would not only adversely affect the economic interest of the railways, but also might affect the commercial information relating to the third party, which is exempted under 8 clause 1 subclause D. This is a very important judgment. Kindly note it. that for the economic interest of the railways, no information can be given, as I have already told you. Misleading information regarding bill. You cannot give, RTI PIO cannot give the misleading information. Even if that information is available, you should have to give the correct information. And even if it is available from the APIO, if that information should have to be given properly. This is the cardinal principles. Misleading information is not allowed. So this is all about. Next. Information regarding cleanliness and maintenance of the train. If this is voluminous information, appellant short information regarding cleanliness and maintenance of train in 90 stations for a period of 10 years. This is a voluminous information and cannot be given. During the respondents, this is all about. Kindly go through with that. Information, arbitrations, award and contractors. In the case of Shri Shankar Sethi, the applicant sought certified copies of 32 documents, mostly relating to the constructions of board, projects, single line, tunnels, and also with respect to particular date 3991 to 3591 related to KRCL entered into with the parties. Then, on going through 32 documents, which the applicants has asked for, the commission's notice that consisted mostly of arbitration award related to contractors. Since the awards has already been produced, the commission considered this to be in public domain and saw no rationale for holding back or non-disclosure of such documents to the appellant. The commission directed the respondent to provide for the inspection all documents asked by the appellant and also to provide him photocopies of the documents that have. Here, the pertinent questions is that after tender contract and arbitration, everything has been covered and it is in public domain. So, what is the harm of giving this information to him after the entire process has been completed? So, the photocopies of the documents can be allowed. Third party does not have a veto. This is also an important thing. Here it has been told that if any information relating any matter, it is related to third party. Now that third party is telling you that this information is a secret information and it is a confidential information, should not be given. Then what is the duty and responsibilities of the PIO? PIO will consider it, give a notice, all the paraphernalia he will complete. But it is not the third party's veto that on the basis of the telling of this particular information, that it is a confidential information, only by mere telling, the PIO will give that it is a confidential information, cannot be given. Third party cannot be a veto. Third party information which he is giving, he may tell according to his own story, that is the confidential information. But it is the discretion. That is why the quasi-judicial power under section 4 clause 1 has been given to the PIO. He will judge with his actus prudence that whether that information can be sufficed for public interest or not. If he thinks that it can be given, then that information can be given. He has got the discretion. Provided that if it is related to trade and commerce related clause, it cannot be given. But by dint of the directions of the third party, he cannot be a veto power on the part of PIO. Now, therefore, I would like to conclude. Before the conclusion, I would like to mention that what are the duties and responsibilities of the citizen, what is the duties and roles of the PIO, what is the duties and roles of the information commissioners and powers, and what is the public authority. So these are the paraphernalia I have mentioned. here you should have to see that the citizen's right means a citizen. Under section 3 of RTI, citizens can only apply for application, and the citizens is the applicant. And what is the duty? He will obtain information. A citizen will obtain information. He will seek assistance. The citizens has every right to seek assistance from the PIO and choose language. He will choose his local language, Hindi language, English language, and his local language as the case may be. And he has got the power to appeal under section 19 of the RTI. Then what is the role of the PIO? The vital role or the basic pillar of the RTI is the PIO. PIO and APIO is the basic pillar of RTI because all the information keeps coming first to PIO, and PIO is the only person to suffice the information. He has got the moral responsibility and duty and responsibility. What is his role? He will receive information. If any applicant is giving the information, he will receive information. Disposal of the application. He will dispose it of within 30 days and obtain information. He will again obtain the information. Collect required fees. If he is a BPL card holder, no fees. If he is not BPL card holder, an amount of ₹10 will be fees and additional fees will be charged. And render all assistance. If he is a blind person, if he is a physically handicapped person, if he cannot go to the place, he will render all his help and assistance to that particular applicant to get the information. Then public authority maintain records. The duty, it is mainly the duty and responsibility of the public authority to maintain records. He will maintain all records. Suo motu disclosure. He will make disclosure suo motu under section 4. There are different categories of disclosure through internet, through media, through public disclosure system, every manner and all respect he will disseminate the information. He will computerize the records and preserve the records and dissemination of information. These are the important activities of the public authority. And last but not the least is the Information Commission's power. Though it is not related directly to us, but we should have to know what is the duty and responsibility of the Information Commission. He will issue summons. When the applications comes, he will issue summons. Scrutiny of evidence, the evidential records, he will scrutinize the evidential records. Call for witness, he will see whether the witness is available or not, he will call for witness. Second appeal, he will dispose it of within 90 days. And penalty, if he fails to give the information with a malified intention, or if he rejects the information without any rhyme or reason, he will be penalized an amount of ₹250 to 25,000 and recommend disciplinary actions. Then he has got the power to recommend disciplinary action. So these powers are very stringent power given to the CIC to impose on the PIO. So this is in a nutshell on all the matters. Though RTI is a vast chapter, go through with the rules and regulations, go through with the Supreme Court's and High Court's judgment. But in a nutshell, the RTI is a platform through which the citizen's right is empowered, and it has been built up a new democratic career in the coming years. And the main pillar of RTI, as I have already meant accessibility, transparency, and accountability. These are the most important things in the RTI, and these are done to combat corruption. And combating corruption will emanate or will give an emergence of a new democratic governance, perfect democratic governance. With that, I would like to conclude this session. If anybody wants to ask any question, this is my mobile phone number. I am again telling 96012 960-1285933. I am repeating 960-1285933. This is the mobile phone number. You can ask me in my chat box, and I will be answering all these questions with a short spin of time. And those who are desiring PPT, they can give information so that I will be sharing the PPT to all of you. So nice to meet you all here and all the participants. I would like to once again thank you to all the participants here. But go through with the books, go through with the Supreme Court rulings and regulation, go through with the CIC. These will be helpful and add a cap of glory. Railway is fighting so many cases. They are the greatest litigant, but Railway should not be overburdened with this RTI. You people should have to be very much well acquainted with the RTI because rules and regulations are changing, and due to change of time, we should be very we will be very beneficial if we get the rules and regulations with us. So kindly have an interactions over phone in regards to the RTI matters, because some questions are very tricky in RTI. The other people are in an embarrassing position in giving the answers. So you should be interactive in your session. Now I will ask you some question. If anybody has got any doubts in regards to RTI, and I would like to know your understanding in regards to RTI. What you have learned.
Participant can unmute themselves and ask any question. Participants can unmute themselves.
Chandan Kumar has asked, what are limitations in RTI? We hold during the providing the information. What are the limitations in RTI? Can we hold during providing the information? Now, gentlemen, Section 8, Section 9 and Section 11 also, there are some limitations. And on the basis of such limitation, as I have already told you, हमने आपको बताया है कि इस limitations हमारा संविधान के जैसा है, 19 क्लॉज 2 में जैसा रेस्ट्रिक्शन है, आरटीआई में भी सेक्शन 8 क्लॉज 1 से ए बी सी डी ई एफ ऐसा 10 रेस्ट्रिक्शन है सेक्शन 8 क्लॉज 1 में, सेक्शन 9 में, सेक्शन 11 में और सेक्शन 10 में भी है. इस जो सेक्शंस है इसके तहत जो रेस्ट्रिक्शन है यही लिमिटेशंस है, और ये लिमिटेशंस को मुद्देनजर रखते हुए हमें आरटीआई की जवाब देना है. नेक्स्ट, एनी क्वेश्चंस? Another man has asked, Mr. Durga, sir, should documentation free be called for when supplied in PDF? From example, when information runs into many pages. I am repeating, what is your question, sir? Should documentation free be called for when supplied in PDF form? Example, when information runs into many pages. Your questions is to some extent, you give me in the mobile chat box, I will be answering the questions. The third one, your question is not clear what exactly you wanted to know. Third one is that, what is his name? Who will decide whether request is related to life and liberty and not otherwise? Now, gentlemen, this is a very good question. What is his name? That it is not. What is it? CA2PIO. Western Railway. CA2PIO. Now, this is a very important question. Who will decide? Now, when any human rights violation is taking place, or when any corruption charges is taking place, there is a law enforcing agency. That law enforcing agency will be able to determine on the basis of inquiry that who is the violator, and on the basis of the fixing of the responsibility, the persons found guilty, and that information will be determined by the inquiring officer or through inquiry, through independent inquiry. So deciding factor in relation to life and liberty is the person inquiry officer. Am I clear to you? Deciding factor is the inquiry, and on the basis of that inquiry, pensions. Just a minute. His pension is within. Somebody has told. Who will decide whether the request is related to life and death? That is inquiry. Inquiry is the determining factor. इंक्वायरी से ही पता चलेगा वो आदमी ह्यूमन राइट्स वायोलेशन किया है कि नहीं, और वो आदमी उस व्यक्ति उन्होंने ह्यूमन राइट ये करप्शन से रिलेटेड है कि नहीं. फॉर एन एग्जांपल, नॉर्थ ईस्ट में बहुत सारे केसेस हमारे एक्सपीरियंस में है कि जैसे बहुत सारे सिक्योरिटी बोर्ड, सीआरपीएफ, बीएसएफ, आईटीबीपी, एनएसजी, सीबीआई एंड रॉ एजेंसीज हैं, और ये इंफॉर्मेशन लॉ एनफोर्सिंग एजेंसी किसी कारण के वजह से गोली चला देता है, या तो उसमें अपना पर्सनल रिलेशन इन्वॉल्व रहता है, तो वो तो उनका इंक्वायरी होता है, और इंक्वायरी होने के बाद ही वो गिल्टी प्रूफ्ड होता है. गिल्टी प्रूफ्ड होने के बाद ही उस आदमी को सजा मिलता है. तो इंक्वायरिंग ऑफिसर्स का जो रिपोर्ट है वो रिपोर्ट ही सबसे इंपॉर्टेंट है. विल साइन, somebody has asked,
sign out or sign off for running staff and their alcohol test information come under section 81J.
The question is, will sign on and sign off of running staff and their alcohol test information can come under section 8 clause 1? Just a minute. Will sign on and sign off running staffs and their alcohol test information can comes under sections 8 clause 1 subclause J. Suppose sign on and sign off, it is in the public domain. That information is under public domain. If anybody wants to know, you cannot hide it that it is a fiduciary. For his relation, for that particular person's information should have to be given. You cannot hide that. That information can be given. If application only contains mail address, that too, what is it?
Something like ABCD and no other information should be. Yes. Information should be that under section 3.
Just a minute. If an application only contains email address, that too something like A, B, C and D, yes, and no other information should be dealt under section 3. This information as you have mentioned to be provided. This information, email is an information, and this information should mandatorily be provided. What is in Hindi?
Please explain in Hindi.
This information, okay. This is the same information. Okay, I will see it in my chat. Give it in my chat box. I will give it. The information can be provided. A, B, C, and D. That is what. This is the same information can be provided.
Hindi में मांग रहा जवाब.
अच्छा, it will be given in Hindi in my WhatsApp. Okay. Then
अगर सेमिनार हिंदी में करें, अगर सेमिनार.
Okay. I tried my level best to give it in Hindi because it will time. Because next time I will try my level best to give a Hindi versions also. I think that many people are Hindi Bhashi. Therefore, I will be able to try my level best to give it a Hindi versions also. And I will prepare my PPD also in Hindi. If your demands is that, I will prepare my Hindi versions also. Next.
वही है सर, आदरणीय महोदय कृपया राजभाषा हिंदी में कहने की कृपा करें.
Okay, I will go through with that. Yes, this is a very good options. Please explain 8 clause 1 subclause J clause further. If someone asks details of the charge sheet of another employee, can it be denied under section 8 clause 1 subclause J? Yes, definitely it can be denied, because that it is a third party information mentioned. I would like to mention, repeat, that somebody, again you just here, who has given it that. This is a very good question. Please explain. I will explain in my chat box. The questions, the pertinent questions is, if someone asks details of charge sheet of another employee, can it be denied under section? Yes, it can be denied, because it's a fiduciary relationship. It's a third party relationship and it can be denied.
सर वही है, कृपया सेमिनार हिंदी में करें.
I will try to do this webinar in here. Also, please further explain clause 1 subclause A maximum. Okay, I will explain it. There are third party, that is fiduciary relationship. Fiduciary relationships is between two persons. That is a restricted relationship and it is based on trust. Third party relationship, that is a fiduciary relationship and it is based on trust. Trust means कोई भी विश्वास के दौरान अगर दो पार्टी के साथ, दो आदमी के साथ अगर जो ये इंफॉर्मेशन एक्सचेंज होता है, वो से थर्ड पार्टी ये विश्वास के ऊपर निर्भर करता है. जनरली दिस इंफॉर्मेशन कैनॉट बी शेयर्ड विथ अदर्स, बट फॉर ग्रेटर पब्लिक इंटरेस्ट वी आर शेयरिंग दिस इंफॉर्मेशन. मैंने ग्रेटर पब्लिक इंटरेस्ट को आपके बाद बताया है कि कोई भी अकाउंटेबिलिटी किसी का हो, पब्लिक इंटरेस्ट का, ह्यूमन राइट्स का, ह्यूमन राइट्स ये हो, एनवायरनमेंट हो, मेनी मुद्दे हैं जिसमें आप इस इंफॉर्मेशन को ग्रेटर पब्लिक इंटरेस्ट के दौरान आप कर सकते हैं और उसको आप दे सकते हैं. नाउ वेरी गुड. व्हाट इज द फुल फॉर्म of ACR? Somebody wanted to know annual confidential report. This is the full forms of ACR, and